Hi, my name is Dr. Devaruti Haldar and I'm the Managing Director Honorary for Center for Cyber Victim Counseling. In this session or in this video, I'm going to discuss about a very important issue for especially all children and also for the parents. Also, this would be very important for all the teachers. I have seen in many cases that children are nowadays taking to online platforms to take revenge upon teachers. What are these mechanisms? What are these modalities of creating some kinds of content to take revenge on teachers? For example, the child can create an impersonating profile. The child can create some contents which are extremely derogatory. These can be something like a comment which can actually attract trolls, and these may not be cyberbullying because in most of the cases the child may not actually target the teacher's profile. What the child can do is that the child can start some discussion taking the name of the teacher. Obviously, in such cases, the teacher will not be present in that online forum. So the child can carry on the discussion, which is obviously not very happy discussion, with the child's friends or in a WhatsApp group or even in a bigger group, in a public group. In such cases, it must be understood that these kinds of contents can also be considered as defamatory contents, and if this is in a very bigger way that the bullying and the trolling is attracting more persons who would put their posts, who would put their comments, etc., and if it is seen that the impersonating profile which may or may not be created as part of that particular discussion is also attracting many other sorts of activities, including throwing some comments on the appearance of the teacher, on how she teaches, or even forget about how she teaches, on how she looks, and whether the teacher is available for any sexual soliciting, etc., or not. All these things could be actually considered as offences under Information Technology Act 2000, amended in 2008. Now, considering the fact that the offender is not a major, that means the offender is not an adult, can IT Act be applicable against these children? I have seen in many schools or even in many other places, societies, etc., the parents who may not be happy with the teachers or the schools come up with a question that my child has done this, but generally the law will not touch my child, and we just want to say that we are sorry. But we must also understand, and in relation to this, I would like to also mention that in the schools, the teachers feel very disrespected. The teachers have asked me, many teachers have asked me whether the child can be considered as an offender, and if in that case the child can be considered as an offender, what sort of punishment, what sort of rehabilitation mechanisms may await for the child. I need to tell all of you that Information Technology Act 2000, amended in 2008, please remember here, POCSO, Protection of Children from Sexual Offences Act, will not be applicable. Why? Because under POCSO, the victim is always a child. But if it is a woman, especially, who is being targeted, then definitely IT Act 2000, amended in 2008, may be applicable. Plus, if this is something which is more than just commenting or just creating an impersonating profile, etc., and it goes on to stalking, it goes on to creation of some kinds of sexually explicit image, or even for defamation, for throwing some kinds of criminal intimidation, all these things, it will also attract Indian Penal Code. For IT Act, the child can also be considered as an offender, because under the IT Act, it says whoever. which means that irrespective of the gender and irrespective of the age of the person can be considered as an offender under the IT Act. Now, IT Act has to be interpreted from the perspective of Juvenile Justice Care and Protection Act 2015. What does this Juvenile Justice Care and Protection Act say? If the perpetrator is a child, then the whole procedure, that is the criminal law procedure, or what we say is that CRPC procedure, it is to be seen from the perspective of child right. But that does not mean that the child will be going without any sort of punishment, or I would not say punishment, rather the child will be scot free. It cannot happen, because then the whole criminal justice system or the whole right system, human rights system, will fail. In that case, what happens? If the woman concerned or any other person who is trying to help the woman comes up, lodges a complaint against that particular person who has created some kinds of content, which can be sexually explicit content, which can be impersonating content, which can be even stalking, which can be something of misusing of the data, misrepresentation of that person, particular person, or even when it goes for unauthorized access to the device, to the data, etc. of that particular person, and through that particular person, if the school data is also affected, then this particular person who is a child and who has committed the offense may be seen as an offender under the JJ Act. And under the JJ Act, it has been stated that the child will not be allowed to go scot-free, but some kinds of admonition should be there, which means that the child should be warned about what he has done. The child should be immediately put up in the rehabilitation course, whereby the child would be made to understand exactly what sort of mistake the child has done. In certain cases, the parent of the child can also be considered as vicariously liable. These things have happened especially for motor vehicle accident cases, but I would rather suggest that in cases where the child has committed any mistake, and if the child is pretty mature, that means we have to see from the Indian Penal Code perspective, where the maturity of the child, that means the lowest level of maturity of the child has been fixed to, like, or rather I would rather say that 12 years is the age of criminal maturity, like when the child understands that whether he has committed any crime or not. That age is 12 as per the Indian Penal Code. And here we have to see it from the child right perspective also, which says that it should not be too low, but it should be in a moderate age. Now, if the child is 12 and above and the child has committed such kinds of mistakes, then it is the duty of the, because the case will then go to JJB. And please do remember that the person concerned, that is the victim, must report the matter to the police, to the nearby police station, and also the police must register the case. Why? Because there is a hidden benefit for the child. If the child is not made to understand that this is a mistake, and whatever the child is doing might have an impact in future on his or her reputation, on his or her life, etc., then the child might feel that this is absolutely normal, which is not in reality so. Hence, if the case goes to the police station, and from the police will understand that the offender is a minor, in that case, the whole JJB system will be taking over the CRPC system. Sorry, the JJ Act will be taking over the CRPC system. And in such case, what will happen is that the child will be called for obviously interrogation in a very much child-friendly way. Then the parents will also be told to monitor the child's online behavior. The child will be put up for counseling, etc. The child will be strictly monitored, obviously by the probation officer and also by some counselor. If, again I'm telling, if the child has committed something which is gravely offensive and which may have provoked the teacher to commit maybe suicide, or may have provoked the teacher to take up some steps like self-harming, then also the child will not be going scot-free. In all these cases, please do remember that JJ Act very clearly says that if the child is between 16 to 18, then the child can be considered as an adult for the purpose of criminal justice administration of criminal justice mechanism. However, if the child is matured enough to understand what is the motive for doing that and how he has done that, and what would be the impact on that particular the victim, then definitely the court and the whole criminal justice mechanism or the whole criminal justice administration may take even stronger action on the child in order to make him understand whatever he has done is not correct. In such cases, what may happen? Generally, the JJP allows the child to go home or to go in a safer place with the parents if the child has committed any mistake. And this sort of admonition or leaving the child, obviously after taking the security bond, surety, etc., it is actually for the benefit of the child. But if the court understands that it is not for the benefit of the child, because if the child is given the device again and the internet connection again, then the child might commit some kinds of like offenses, mistakes, etc., which in turn will be again putting the child in such kinds of circumstances. Then definitely the court can consider making the child secluded from that particular device or the internet, which through which the devices through which the child can actually reach out to internet for the sake of the child. Always remember that juvenile justice administration looks to the child rehabilitation from the perspective of child right. In such case, what may happen? The court might, that is the Juvenile Justice Administration or the JJB Juvenile Justice Board, might consider like rejecting the bail petition of the child, even though these things are very rare. But in abroad, in many other jurisdictions, this system is now being followed. In such case, the bail may be cancelled and the child may be put up in the observation home, so that the child will be monitored properly and not through the parents or not through any third person other than the probation officer or the observation home management. And the court might decide for how long the child is going to stay back in the observation home. So in this case, we must understand that the child does not go scot-free. There are rehabilitation mechanisms, there are punishments in the sense of rehabilitation which goes on for the child, and the child may also be monitored even in the school. Coming to the question of what the schools can do if these kinds of things are going on against any teacher by the children, it is the duty of the school first of all to report that matter to the police. Do remember that CRPC, JJB and IT Act actually give the power to the police officer, investigating police officer, to collect the evidences, to ensure that who the person is who has been doing this, and whether, obviously if you see from the perspective of JJB, to understand whether the child is doing anything because of some outside influence. That means it may happen that the child is being used as an agent to harass the teacher, or the child is being used as an agent to steal some data from the teacher, or even the child is doing something because somebody has told him, somebody has groomed him that you have to get the image of the particular woman or the man, and then that particular image will be misused. In such case, JJP, IT Act, IPC, CRPC, all these things will go hand in hand to actually rehabilitate the child and to make him a different, reformed person, so that he does not commit that mistake again. Coming to the punishments under the IT Act and how they are seen from the perspective of JJ Act. For example, if the child commits any mistake which is amounting to publishing, circulating, etc. of sexually explicit matter, definitely no offense goes generally without any punishment which is lesser than 3 years. That means the minimum punishment could be imprisonment for 3 years plus fine. In certain cases, if it is something whereby after committing the online harassment, the teacher has been affected by some offline harassment also, then both these things could be coupled. That means the online harassment and the offline harassment would be coupled together, and it would be seen that for which particular offense the punishment is higher. But since the offender is a child, so definitely the perspective of the JJB would be to lower the punishment, but to make the child understand that whatever he has done is not correct. So in such case, as I've just mentioned, from the age of 16 to 18, the JJB may consider that the child has done something which is like he has done, or he has taken the decision in a very matured way, so he should be tried as an adult. If the child is from the age group of 13 to 16, then definitely the harsh punishments will not be applicable, but still then he would be under monitoring of the probation officer, and some kinds of order may be passed by the JJB whereby he may not be allowed to connect to internet for committing these kinds of, like, nuisance or offenses again. In that sense, obviously the school plays a major part in monitoring whether the child is using internet at all, whether the child is accessing device at all, and if the child is accessing device or internet, for what purpose. We must understand that a child will use internet, will use device, because this is the age of digitalization, this is the age of internet. So even for learning something, for example maths or science, etc., the child may look for internet guidance, but in that case it does not mean that the child will be using internet for negative purposes. So this is for the parents as well as for the teachers, that especially for the parents, please do monitor what your child is doing with the device and also with the internet. For the teachers, if the teachers come across any sort of offense, mistake, etc., that have been committed by any child, for example, the teacher has come across any post which is impersonating any of the colleagues or herself or himself, or even the child is using the school's name, then immediately that particular person who has come across or seen these things must report the matter to the school management. The school management must not suspend the child forever, that is not the answer, but must contact the concerned police officer, especially the higher level police officers, must also concern stakeholders who are dealing with like cyber crimes, especially NGOs, etc., and also must take the child for complete counseling. If this does not work, then definitely the police officer can register the matter, and as I stated, the matter can go through the JJB, and the child can be admonished by the judicial way and not by private or personal way. Our lookout as stakeholders, as adults, should be that the child does not misuse the internet and any other digital devices for harassing teachers, for taking revenge, because the child should also understand that whatever the teacher is telling, maybe there is some good point which can actually improve the child's performance. Obviously, in this matter, we have to understand, if the teacher is doing something which is in the category of corporal punishment, or which is discriminatory, or whereby the teacher is doing everything voluntarily, intentionally, then definitely there are different mechanisms, and even JJ Act also can help in pitching, including IPC and also POCSO, if there is sexual offences that may have been committed by the teacher against the student. But apart from this, if the student feels, if the child feels that the teacher is not giving me good marks, that the teacher is going on scolding me, that the teacher is going on discriminating me in the class, and also if the student feels that I'll make a gang, I'll make, say for example, an online gang and target the teacher, then definitely this is not a rational idea of making the teacher understand what you are doing is not correct. For this, the child and the parents must consider going to the school management and reporting the matter to the school. If the school management is not listening or refusing to listen to the particular child's plea or the parent's plea, then definitely the parents can go for the DEO, District Education Office level offices, or even to CWC, and through this the grievances of the child can be submitted, can be heard. But please do remember that internet, misusing the internet, like creating some kinds of revenge taking posts, etc., targeting the teacher is not a good idea. So I hope the students, the parents, and also the teachers, the schools will remember that internet is for positive use, internet is not for negative use, and by any means, if the child has committed some mistake which are considered as offences under the IT Act, do not please suspend the child, do not thrash the child, but handle him in a very much rational way, because judicial system is there which will be child friendly, which is child friendly. Apart from that, the other stakeholders are also there to make the child understand, and also we must, this is our duty as human beings, as adults, to make the child understand what mistake he has done, to reform the child, to rehabilitate the child, and to make him a better person. Thank you so much.